Oh, that's not necessarily true. Being neutral and detached doesn't mean that you have to give up control. One of the principal functions the mediator has is to control the process, to make sure that all of the participants, follow the rules, are civil, and don't get out of hand, and to direct the conversation, to direct the discussions, to really, it's like being the captain of a ship. And if you take your hand off the wheel for any significant period of time, the ship's going to go out of control and you're going to lose your way. So the mediator has to have the trust of the parties. He has to have or I shouldn't say the mediator, he or she, because we have excellent mediators of both genders. So it's essential that the mediator have control and trust.
After you've applied some of these techniques, you've talked to the parties, you've identified the issues. You do mostly commercial cases. Doesn't it get down to money in the final analysis?
Well, that's one of the problems is that the remedies provided by the law usually are in terms of money damages, and of course some injuries never can be replaced by money. It's a poor substitute. But there are many cases where it's been referred to as innovative solutions, where you come up with plans for the parties to work together, or to exchange other properties, or to assist each other in the entrepreneurial areas, not in terms of dollars. So even though dollars are in most cases the ultimate answer, in many instances you can come up with innovative solutions.
At the end of the
So I should add to the requirements for mediators should be innovative.
Okay. At the end of the process, what you have, as I understand it, is an agreement between the parties. Do you find that the parties, after having been through this process, want to comply, or is it often necessary to go to court and force a party to comply with the deal that he or she has made?
Well, there was only one instance in my entire experience of conducting mediation sessions and arriving at consensual agreements where we've ever had to go back to court to enforce the agreement. And that was because we were dealing with far-flung parties all over the globe. From Australia, Belgium, France, and England, and the United States. It was a patent infringement case. And we had to conduct a mediation by telephone. So we had these huge telephone conferences that lasted for hours among the parties in these far-flung corners of the earth. And when the agreement was finally arrived at, I restated it over the telephone, and it was translated into French. It was translated into Australian English for the Australians and British English for the people in England. And I made notes of it. The agreement then was everybody kind of shook hands electronically. The principals shook hands electronically. And then we signed off, and the lawyers were then going to draft up a formal settlement agreement consistent with the oral agreement. And of course, when you turn it over to the lawyers, for some reason they have to continue to press to take advantage for their own clients. As a consequence, I was compelled to draft the agreement consistent with my notes, and then to have it specifically enforced in court against the parties. And it was tested through the Court of Appeals, and that's the way it works when you're unable to get that eyeball-to-eyeball bond that's so essential in the mediation process. And if we had video facilities at the time, I'm sure we never would have had to go to court.
Judge McCue, you talked about the one experience that you had when the parties had to go to court in order to enforce a mediation agreement. Is it your experience that judges, either in enforcing mediation agreements or generally with the process of mediation, are supportive of what you're doing?
Oh, I think that today the judges, both federal and state judges, are totally supportive. It wasn't always that way. When I first got into this concept of mediation, it was a result of necessity. Back in 1970, when I was first appointed when I was first appointed to the bench, the caseloads in the courts were so overwhelming that there was essentially no forum for the resolution of civil cases. So civil cases were on the back burner. It took years to bring them through the litigation process to trial. And there was essentially no forum for the handling of civil litigation. I felt that that was wrong. I did everything I could to speed things up to make room for the civil litigants. Then I discovered all they did was fight about all these inconsequential problems in the discovery and the civil procedure area. So I found myself essentially mediating discovery disputes and disputes involving the lawyers in the initial stages of the litigation process, which was withholding ultimate resolution of their clients' claims. So I realized that I was conditioning these lawyers and the parties, because frequently I would order the parties in because they were the ones who weren't cooperating, to mediate the procedural disputes. And I said, why not do it substantively? So I began immediately to condition the lawyers and the parties to substantive mediation efforts. And the result was extraordinary. We were able to clean up the civil calendar in a matter of 2 or 3 years, bring it up to schedule. Suddenly other judges who would chide me at judges' meetings for talking about mediation and settlement in lieu of trial, suddenly realized that, maybe there is something to this mediation process. And it wasn't long before alternative dispute resolution programs were sprung up in California and then throughout the United States as the word spread. So clearly, the judges are one of the main beneficiaries of the mediation process, because it allows them to do those types of cases that only the exercise of power will resolve.
Our audience is international. We have many listeners in Latin America. We've got listeners throughout the United States and Canada. Do you see the mediation process as something that can be beneficial in an international business dispute?
Why, there's no question about it, because that's the ultimate role of mediation, is to resolve international disputes without using the compulsion of force. And that clearly involves the exchange of ideas and perceptions of what the facts are surrounding the disputes on the international scene. And it also allows the process to accommodate the differences in culture, the differences in background, the differences in religious and social differences with the appropriate forum. A mediator or a group of mediators can put together these what appear to be conflicting ideas and come to a consensual understanding of what they really are. I had experience involving Native American nations, Indian tribes, the Navajo Nation, the Hopi tribes in the United States, which was essentially an international dispute because we had two sovereign nations in dispute with each other, being held in trust by the United States, a third sovereign nation. And we were able to, having made up our mind to do it, to sit down at the negotiating table, or in certain instances to go to the scene of the conflict, and to sit down and with an open heart and an open mind, view the other person's problems in their eyes and from their standpoint. And I have a great deal of hope that mediation will become accepted internationally.
On the personal level, do you find being a mediator and working in this mediation process as something that's valuable and satisfying to yourself?
Well, I've done a lot of things in my life. I started out life as an engineer and a scientist. I've been fortunate. I've always had excellent opportunities and experiences. I've never, ever realized the satisfaction that I'm getting out of this mediation service that's being provided. I find it personally very rewarding. And hopefully, whoever keeps track of these things in the hereafter will give me some credit for it.
If you had a couple minutes to say something to our audience about the mediation process, what advice would you give them?
I would advise them to very carefully evaluate their perception of the wrong that was inflicted upon them by the party that they are in conflict with, to examine whether or not they had a role in creating the situation resulted in that reaction which inflicted harm on them. And then I would suggest that they immediately consider the use of the consensual process to resolve the dispute, rather than resort to the costly and expensive process of suit and countersuit and reliance on the legal forum, which is totally unable to provide a complete and satisfactory resolution of the dispute. They have it within their own control, in their own perception, to resolve the problem if they'll take the initiative and make a call to the offending side and invite them to a conciliation and mediation process.
Judge McCue, thank you very much for the time that you've given us today. You've had years of experience. It's been a pleasure listening to your observations.
Well, thank you, Mr. Page. You're very kind. I do my best. I keep on trying, and I never give up.
That's what makes you a good mediator.
And you and I will mediate.
Thank you, Judge McCue. We will now begin with the second question and answer session. Our first question is a fax. It is from La Universidad Estatal a Distancia, San Jose, Costa Rica. The question is, how would I get a case into mediation with an agency, and how much would it cost? Mr. Cooper, would you like to address that?
Thank you. You can simply contact the agency, CAMCA, the Center for Commercial Arbitration and Mediation of the Americas, which is a joint program of the American Arbitration Association, the British Columbia International Commercial Arbitration Center, the Arbitration Center in Quebec, and of course the Chamber of Commerce in Mexico City. There are panels of mediators, arbitrators as well, but panels of mediators who have been designated by those agencies for international disputes in the Western Hemisphere. You can also turn to the U.S.-Mexico Conflict Resolution Center in Las Cruces, or to the American Arbitration Association, and there are several other agencies. There are several new agencies in Argentina that have been formed to promote mediation, and several in the United States. You simply have to contact one of those, either party, and most of them have trained staff who will help educate the other parties about the benefits of mediation and help encourage them to join into the process.
Judge McCue, I know that you've gone into the offering of private services. Are many judges doing that in addition to the agencies that are available?
Well, a number of retired judges have recognized the need and are willing to utilize their skills to help further this whole program of mediation and arbitration. And it seems to be an evolving trend now, that when judges become senior and because of legislative requirements they're forced to retire, or because they feel that they've had enough of the formal life and would like to devote the remaining years to informal mediation, which is more productive. A lot of them are doing it. So it seems to be a new career trend that I discern.
Our next question is live. It is coming in from the U.S.-Mexico Conflict Resolution Center in Las Cruces, New Mexico, from its director, Nancy Aretskin.
Good morning. I have a question for Judge McCue. Do you need to be a lawyer or a member of a bar association to be a mediator?
Okay, so as I understand the question, is it necessary to be either a lawyer or a judge to be a good mediator? And the answer to that question is clearly no. We look back to that in biblical times. You know, the first mediator was Solomon, in that dispute where he developed his rule that's now enshrined in many people's minds, that all you have to do to resolve the problem and make these women happy is to split the baby. And what you need to be a mediator is patience. You have to have the ability to listen carefully to what's being said, to evaluate, and normal intelligence mixed with some sound judgment and experience in the area in which the conflict lies. And I think if you possess those qualities, you're well on your way to being a mediator. It's not necessary to have a law degree or to have been a judge in a formal court.
Judge Brennan, what do you think about that?
Well, in New Mexico, we have an alternative dispute resolution committee that was set up by the Bar Association, and one of our first questions was who is to belong to this particular committee. And some of the members felt that only lawyers should belong since it was a Bar Association committee. But as we began to look at mediation in the community, we found out there were already many community mediators who did not have any formal law training who were out there in the community. So we decided to incorporate them into our committee so we could look at mediation at large. So it's not even really a question for the bar to decide whether or not non-lawyers should be involved. They are involved, and as Judge McCue pointed out, many of them are doing excellent jobs.
Thank you very much. Our next question is live. It's from la Universidad Tecnológica de Panamá in Panama.
Buenos días.
Good morning.
Todo mediador ofrece
Every mediator offers an opinion on a conflict, of course filtered by his context and experience, right? And how do you select a neutral mediator that will guarantee an impartial opinion and a fair opinion?
Mr. Cooper, how do you select a neutral arbitrator or mediator?
We select mediators based on the subject matter of the dispute. We do believe that while you don't have to be a lawyer, and indeed many mediators are not lawyers, I agree with everything that two judges have said, we do think that training and experience in the mediation process is essential. And something which helps move the process along is the subject matter expertise of the mediator. So we are inclined to suggest or nominate mediators who understand the underlying disputes of the parties so that they can come to a quicker grasp of the underlying issues and work towards a resolution.
Our next question is live. It is from el Tercer Cuerpo del Ejército de Córdoba, in Córdoba, Argentina.
Good afternoon. We would like to know, based on the fact that the state has public authority because they are the ones who interpret the principles in the law, is it possible to then have arbitration when there is a law or a suit against the state, when it's the state that is being approached, it's against the state?
Judge McCue, I'm going to direct this question to you in your experience with the government, the federal government in the United States. What has their history been in terms of accepting a mediation or alternative dispute resolution?
You know, well, that's a fascinating question, and I really thank you for that question because it really will helps clarify the role of the public agencies and the government itself when the government itself or the public agencies become involved in the dispute. Now, initially in the early 70s, in the federal courts, when the need for mediation and alternate dispute resolution was clearly visible, in the civil area as well as the criminal area, a substantial number of the litigants were the state governments, the city governments, and the United States government itself. And the United States government is represented in the federal courts by the United States Attorney's Office, part of the Department of Justice. And the official policy, when we initially began the mediation alternative in the federal courts, was not to participate. The Attorney General issued a directive that U.S. attorneys' offices throughout the country were not to participate in alternate dispute resolution programs. They were not to consent to the use of the settlement process in the magistrate judge's court under any circumstances, and they took a firm stand against it. On the theory, I suppose, that the sovereign itself is in a special relationship. It should not be asked to compromise in order to reach a consensual resolution of a dispute with its adversaries. That position persisted for, well, from the early 70s. It slowly eroded because of the necessity to resolve the mounting number of federal cases involving the government and its agencies. We had the Clean Air Act, we had the environmental and toxic waste cases, and the government found itself burdened tremendously with civil litigation. And as the success of the mediation efforts in the federal courts proved the mediation process, the Department of Justice tempered its position, and the Attorney General of the United States has just recently appointed a Deputy Attorney General in charge of the alternate dispute resolution section of the Department of Justice. And that man was an attorney who worked with me in a major dispute involving the international dispute between the Navajo Nation, the Hopi tribe, and the United States. So I would say that initially there was great resistance. Today, the Department of Justice has adopted it.
Mr. Cooper, do you have anything else you'd like to add to that?
Well, today, just to sort of follow on to the judge's comments, today every federal department has a senior official in charge of alternate dispute resolution. So the government is and its agencies are participating every day in some form of alternative dispute resolution.
And I'd just like to add, in the state of New Mexico, the legislature has become so inclined that they've enacted a statute which requires everyone to look into mediation and arbitration before proceeding to suit. And as a result of that, most of our state agencies have instituted mediation and arbitration programs. So the government is finally coming on board.
Thank you. Our next question is live from KTV Comunicações, LTDA in Rio de Janeiro, Brazil.
What training can you offer a person who will be acting as a professional mediator, and to what extent do his innate features and capabilities are these more important than the formal training? To be a born mediator, is that more important than the formal training that you can give a mediator?
Let me divide that question in two. The first part of it, in terms of formal training, let me address to Mr. Cooper, and then to Judge McCue, I'd like you to talk about the innate ability. Maybe we have a different view on that.
Well, I don't know. Obviously, the first mediators were never trained, so innate ability has to count for something. But I think that almost every person can benefit from mediation training, and certainly everyone who holds themselves out as a mediator can improve their skills through training and practice in an organized way. We find, and I think that my own particular agency has done more over the course of the last 15 years to develop mediation training than probably any other in the world. And we have found that at the end of a 3-day or 4-day or 5-day mediation training, people do have an enhanced level of skills. Of course, nothing comes close to practical experience. Role-playing, study is all very valuable. Feedback from mentors is very important. Discussions with other mediators is very important. But nothing really takes the place of the experience of people who are conducting real mediations in front of real parties who have real disputes, and not only disputes over the law, not only disputes of fact, but the emotional content of these disputes is very, very important, so that whether you're talking about innate ability or training, You have to really focus on and confront the issue of communication skills and what one might call sort of soft learning as opposed to the hard learning of the law.
Mr. Cooper, before we go to Judge McCue and the question of innate ability, the American Arbitration Association has offered training throughout the United States. Do you foresee the American Arbitration Association, in conjunction maybe with the ITC or with the U.S.-Mexico Conflict Resolution Center, offering mediation training outside the United States, for example, in Latin America?
I do. And as a matter of fact, in conjunction and with the very solid support of the U.S.-Mexico Conflict Resolution Center, we have conducted initially two training programs in Mexico on mediation.
Okay. Judge McCue, how about innate ability?
Well, I don't really know what that means, innate ability. I don't think people are born to be mediators. I think all persons who are born, if they are fortunate enough to be gifted with normal intelligence, have the ability to become mediators. And through the constant process of both training, formal and informal, experience on the job, the patience and sensitivity to appreciate the ideas being communicated by other persons, and the willingness to sublimate your own ego for the purposes of trying to reach a compromise or try to lead people to reach a compromise, I think you can be a good mediator. But training, education, are all essential tools that a good mediator will, along the way, acquire.
Thank you very much. Our next question is live. It's from La Universidad Privada Boliviana, Cochabamba, Bolivia.
Is that La Bamba?
Buenos días.
Good morning.
Mi pregunta
My
sería,
question is the following.
¿Cuál sería la fuerza coercitiva?
What is the cohesive force that what would be the bond that would oblige the parties to bind the parties to the solution reached through mediation?
Mr. Cooper, you want to address that?
Certainly, although I think one of the judges might like to comment as well. What we find is that since the mediation leads to a mutually acceptable resolution of the dispute by the very definition of the mediation process, that parties overwhelmingly comply with the mediated settlement because they had a significant part in crafting that settlement, in creating that settlement. And of course, when people are involved on a personal level with creating something, they are much more likely to own the result and to abide by the result. In most jurisdictions that I know of, that result is as legally binding as any other contract would be.
Thanks. We have one last question that we have time for, and that is a live question from La Universidad Autónoma de Baja California Sur, La Paz, Baja California Sur, Mexico.
Sí, gracias. La pregunta es,
The question is, what mediation clauses does the NAFTA agreement have, and what are the results?
Mr. Cooper, do you want to take that one, or would you like me to address it?
Well, there are two, and then I think I'll try to read quickly and leave time for you. There are two basic sections of that. One would be intergovernmental disputes, which are quite formal, and I think probably I would turn the podium back to you to respond to. And the other is Section 2022 of the NAFTA agreement, which calls on all of the participating governments to foster and encourage private ADR mechanisms.
Thank you for your excellent questions, but we've run out of time. Thank you, Judge Brennan, Mr. Cooper, Judge McCue. We hope you have enjoyed participating in this video conference, and we hope that our viewers have enjoyed listening to your thoughtful presentations on mediation. We invite you to participate on October 10 in the next program of ours entitled Strategies for Global Competitiveness series. The program is entitled Managing Health and Productivity, New Approaches and Technologies. We hope that all of you will participate in the 1997 International Training Center series, which will include 2 programs on the use of alternative dispute resolution and commercial diplomacy in international commercial disputes. For additional information on the ITC's video conferences, please consult your participants' manual, where you will find the dates and specific topics of the remaining 1996 programs. If you are interested in attending next year's programs or in participating in training sessions, which will be offered by the ITC, please feel free to contact the Center by letter, phone, or fax. On behalf of all of us who collaborate with the International Training Center, I thank you for your participation and interest in today's program. Thank you. See you soon.